My name is Kieran Hoare. I am one of the two principals of Merthyr Law and specialise in self-managed super funds particularly. And today we have Merthyr Law's Senior Associate and Tax and Duty Lawyer, Mr. Tom Walrut, with us. And he is the guy that we see for all things tax. Tom loves tax and lives tax. He is on the state committee for the Tax Institute of Australia and helps with the memberships. And is that right, Tom? Or
state taxes and member services amongst various organising committees for events and those sorts of.
And he's in different kind of tax clubs and, is up with all of the latest rules and the latest happenings. And he even would read his eldest son Atoids instead of nursery rhymes as bedtime stories. And so it's pretty valuable to have a well-experienced lawyer like Tom who lives and breathes tax as part of our team, because we do commercial transactions and we do estate planning and asset protection. And with any of that, we want to know, what's this going to cost me? And is there a way it can cost me less? And tax is always one of those ones where if you have a good look at it, there might be a way that it can be structured that it costs less. And so to a large degree, that's what we're talking about today. Because in any kind of equation, in any kind of where you're thinking about, well, what's the best way if I'm going to restructure, or I'm going to, do something with my assets, or if I want to get them from their current structure into a better structure, whether it's asset protection or tax or new investors or whatever it is, it's what's that going to cost us? And when I started as a lawyer, and it was only just after the GST got introduced. And so at that time, when the GST got introduced, there was that commitment from the states that they were going to abolish a whole array of state taxes because they were getting this GST revenue in. And then we're all a bit upset that then actually transfer duty went up because it went on the GST inclusive price rather than the GST exclusive price. And the states were particularly slow in removing a lot of those exemptions. I know in Queensland, we were promised that mortgage duty would be abolished, and that happened, tick. That duty on the sale of shares in companies would be abolished as long as they weren't land rich. And that eventually happened, tick. And also that duty would be abolished on the transfer of business assets. And that was originally scheduled for, I think, 2011 for total abolishment. And then that got kicked down the road a bit. I will delay that. And then I think it just slided away into the minutes of nowhere and isn't even on the agenda of any of the budget papers anymore. It's about right, Tom?
Yep. If I recall correctly, it was we are indefinitely postponing the removal of stamp duty on business assets until budgetary circumstances allow. So,
which I think the budget deficit is larger than it has ever been, and debt is spiraling, and it doesn't seem like there is an appetite to decrease that. So I don't think budget circumstances necessarily will allow for a while. What about the other states though, Tom? Where are they at with respect to duty, especially with the sale of businesses?
So gold standard, I think, is probably South Australia. It's abolished stamp duty currently on everything other than residential property sales and farming properties. So no stamp duty on businesses. Any of the other stuff you usually pick up here in Queensland. Other than that, Victoria and New South Wales have abolished duty on business assets. WA still has it. And I'll be honest, no one really cares about Northern Territory or Tasmania, so those are off.
Hopefully this is a Queensland-based
Tasmanians around.
This is a Queensland-based talk today, so hopefully there's not too many Tasmanians listening. But that brings us to what we're talking about today, which unfortunately isn't the abolishment of duty for business transfers of business assets in Queensland, but it is something. It is allowing assets to be transferred from certain entities, individuals and partners, and even trusts into private companies for small businesses which can be really handy from that structuring perspective, which we'll be looking at. And also there's been, I guess, a lot of federal exemptions, so capital gains tax rollover relief, small business capital gains tax concessions, that have allowed us to do these kind of restructures to get into better entities, which are better to attract more investors and to grow your business. But for years now, a lot of our clients have been a bit reluctant to do that because the stamp duty cost is pretty significant, Tom.
Yeah, and that's bang on. We've had rollovers for a very, very long time, and we've had a lot of federal government encouraging movement of assets formerly out of partnerships, individuals' names and trusts into the corporate environment for various reasons. But the biggest impediment to that has always seemed to be stamp duty. And I think the perception is that stamp duty is just a dead tax, in the sense that, you know, if you're paying some capital gains tax, hey, at the very least, you get an uplift in your cost base, and, you know, you get refresh cost bases and all those sorts of things. Duty is just pouring money down a hole. So people have been reluctant, I think, to do any sort of restructures, whilst there's been at least a reasonable duty cost, which sort of is why I'm kind of really excited about this ruling, that it helps a lot of the guys that are in the small business entity realm, with a turnover in and around $5 million, or dutiable value of property or market value of property of around 10 million, to get out of those sort of form inappropriate structures and into a company. We probably should preface this all by saying, I think most people are now on board that if you're trading, it's probably best to be in a company, and particularly with the reduction in the corporate income tax rate for companies, when you're still a base rate entity, it's much more beneficial to be in a company and be able to roll over profits and have retained earnings and, you know, recontribute back into the business than be stuck with those horrible Div 7A problems, or having to have the partners take large distributions at the end of each year. And
Div 7A looks to be just getting worse and worse, and it's a real headache for a lot of clients that we see, and they've got some real problems that they're fixing up. And the problem accountants generally, I think, are finding with family trusts is there's only so many people you can distribute to, and then if you're doing well, you know, perhaps you're better parking some of that money in a company for a while until I guess you have a slimmer year. Yep. Tom, before we continue on some more, I guess we've got a few more panelists now, so there's just a little bit of more housekeeping I'll do. So I've introduced Tom. What I'd like to say is we love knowing that you guys are out there, and so if you could use that chat function, you know, let us know if there's any sound problems, if you know, anything's not coming across properly, give us feedback, comment on our haircuts, all of that kind of thing. Then you can either ask questions through that chat functionality, or even better, through that question and answer functionality. So you just slide your mouse over the screen and you'll be able to see where that is. Now, to encourage this kind of participation, not that you need it, any encouragement, but we usually in these things award a bottle of wine, or sometimes more than a bottle of wine, to the best question or the best kind of feedback or participation from the audience. So I'm the arbiter of that. It's non-appealable, so it's completely at my discretion as to who that best question is. And today I've got with me a Parker 95 block Cab Sav from the Coonawarra 2014, or an Eileen Hardy 2012 Tasmanian Chardonnay. And so they're the wines we're talking about. So everyone, please ask those questions, and I will try to have Tom or myself answer them at the appropriate part if we're talking about that issue. Otherwise, we'll deal with a few of those questions at the end. And, you know, any other kind of questions you've got there. So everybody, please participate, and don't just let this be a lecture where we're talking to you. So what we're talking about today is, Tom, quite recently, earlier in October, there was a exemption that was released with respect to transferring certain small business assets over to companies. And Tom, that's not a legislative instrument.
No, it currently doesn't have any, let's put it nicely, this doesn't have any force in law that I'm aware of. I've asked around a couple of people and I've said, what's the basis for this? What's the basis of the tax officer, sorry, the OSR administering the law in this way? And the response was a sort of standard, So assume they've got Crown law advice somewhere along the line saying, oh yeah, you can do this. But this all did, and the reason why sort of this is up there on my list is that I grew up in South Australia and started practicing in South Australia. And we ran into this problem back in about 2012, 2013, where the commissioner did the same sort of thing down there, said, oh, look, I'm going to treat the law as if this is how it should operate. And it all came to a head in a case called Chubb Securities. And what happened there was, in South Australia, they were running the corporate reconstruction exemption for duty under a public ruling. And the public ruling was said to be given under what's called an ex gratia relief which effectively says if the treasurer feels like it, he can excuse someone from paying stamp duty. The problem was the commissioner didn't have the power to apply ex gratia relief. He had to go to the treasurer or the under treasurer, whoever it was. And Chubbs applied for corporate reconstruction. Under the public ruling that was there, they didn't particularly like the result, which was a no, you don't get corporate reconstruction in these circumstances. And when they went to object to the commissioner's decision or the commissioner's application of the then ruling, the court said, well, what do you want us to do? You don't have any objection rights. It's a stated process that the commissioner says, this is how I'm going to apply the law, but you don't have any appeal rights under you don't have any appeal or objection rights under the Tax Admin Act. You don't have any estoppel against the commissioner. You're stuffed. So bear that in mind in terms of this ruling. It's nice, lovely to have it, but it is still currently floating out in the ether a little bit that if you are going to apply it, there is a level of risk with it.
So, Tom, I guess this came about as a budget announcement, didn't it?
I think in Queensland, we didn't, because of the election, we didn't have a budget. So this was one of those announcements, pre-budgety financial thingamabobs. I'm not quite sure what it is, to be honest.
And so there was a question, Jim, when did this start? If this was just a ruling, wasn't this always the way the law was? Not at all. The law does not allow this arrangement. The law, this is the making of the law by ex gratia relief via a public ruling. And so, Jim, your question there about why the start date was 7 September, because this is a new way of, I guess, providing an ex gratia concession under the law. What we expect, though, is that after this period where there's been what I consider to be a reasonably hastily drafted public ruling exemption, that after a while this will be made law and will be put into the Duties Act. And the question, I guess, for everyone to consider today is, where do you stand? Do you want that certainty of it being part of the legislation, in which case they're going to, no doubt, have much more robust provisions with better integrity measures? Or are you the kind of person who goes, well, hang on, while it's a bit loose, there might be some more ability, I guess, to get a better or bigger or stronger duty exemption? And are you the kind of person who will go, okay, well, we've got this exemption, it's got pretty broad application at the moment, and so I want to go ahead with it before they start restricting the application of this exemption?
And I think that's very much the thing here. The ruling is a bit narrow in some of its definitions, or a bit loose in some of its definitions, which seems to give rise, which we'll sort of talk about as we go through this presentation, maybe some consequences that weren't necessarily intended. But we'll bring that out in a little bit more detail.
So I guess everything that we say today, it's our interpretation of what this public ruling exemption is. Tom's had a bit of a chat with some representatives of the Office of State Revenue. And I guess, if we were pushing that envelope and there was a big kind of duty risk there, we're not allowed to just give unexecuted documents for a private ruling. But what we can do is we can ask a few questions behind the scenes and try to develop a bit of confidence of which way the Commissioner would be leaning before we go and sign all of those documents and are committed to, I guess, the Commissioner's whim. So, Tom, this exemption, what kind of person? Who's this aimed for?
So this is principally aimed at three entities: individual sole traders, partnerships carrying on a business, and discretionary trusts. So in having a look at this, we think that the main guys that are going to get benefit out of this are probably some property development partnerships. This seems like it's going to work well for them. Some of your older professional partnerships, legal and accounting firms that are still running as partnerships from the hangover of way back when they had to be. Also maybe some farming partnerships, some mum and dad farming partnerships or broader farming partnerships within family groups. That seems to work well. It's also going to work well, I think, for trusts if you've got any of those old stinky UPEs and Div 7A loans hanging about. That if you're able to restructure out into a company, you might be able to deal with those Div 7A issues quite a bit better. And yeah, obviously just trading trusts on that basis. We'll deal with this in a bit more detail in the next slides, or this slide here and the following one, but just be aware at the outset, it's only going to apply to discretionary trusts. We don't have any extension of this ruling yet to unit trusts. So whilst we have those federal rollovers for unit trusts like 124N and 122A, they're not on the state tax's radar for this ruling and this concession. And having asked around, I'm not quite sure what the policy intent behind that is. You would have thought small non-widely held unit trusts are available or are commonly used within family businesses and small businesses, and their exclusion from this ruling is just a bit odd. But
Tom, let's get into it. Hey,
yeah,
what is this exemption? Who does it apply to? What are the rules? So we say it's small business. What is a small business? Who are we talking about?
Yeah, so basically, let's start at the start. Applies to businesses. So your property that you've rented out in your home as an individual for your home, probably not going to be a business. But anyone carrying on a business in partnership, individual or trust should be fine. So that's the first step. The next step is you have to have a turnover of under 5 million. It's unclear exactly what that might mean at this point in time, because we don't know if it's GST inclusive, exclusive. You've obviously got your fun bits and pieces about accruals versus cash accounting, what your turnover is, where your turnover is meant to be, all those sorts of things. And the other aspect of it is that the value of the dutiable transaction, or the assets that are going over as part of the dutiable transaction, need to be less than $10 million, calculated in accordance with the general stamp duty rules, which are market value.
So Tom, that's one of the things that seems to be an opportunity under the ruling is that it doesn't seem to define revenue to be averaged over any period of time. Doesn't seem to aggregate any groups or related party groups with respect to revenue.
That's bang on. So the easiest comparison to make would be for something like a small business concessions for capital gains tax. Through those concessions, any connected entity or affiliate, so 40% interest, 20% depending on your circumstances, and anyone who controls that entity, their turnover is lumped in to the turnover of the target entity. currently under this ruling, we don't have that either for turnover or for the $10 million worth of dutiable property, which is interesting. To put it into context, if Clive Palmer started a company and had a less than $5 million turnover, and if Clive Palmer started a business individually and he wanted to transfer assets over to a company, notwithstanding, so long as he had turnover of less than $5 million in the relevant year, and the value of the property going over to this new company was less than $10 million, it looks like he should get it, which I just don't think is going to stick around once we actually get some legislation for this.
So Laura Gamble just asked, gave a scenario, and we've got lots of, I guess, clients, and accountants will have a few clients in this same boat where they've had a client who's wanted to roll over to a company because it's a better structure from, new investors, from that ongoing tax rate and, your working capital, keeping in the entity for a myriad of reasons. But stamp duty was about $200,000. So it was ruled out, that was just too much of a hurt when no one's actually paying the money for this. And now this exemption's come through, so it's looking pretty good, but turnover is $7 to $8 million. And then what about if we, siphoned out one of the revenue sources of the company to another one, or didn't transfer all of those? So we got that revenue down to below that $5 million mark. Is that going to be subject to any anti-avoidance provisions?
So we'll get into this in a little bit more detail shortly, but while this sort of goes back to that risk thing we were talking about earlier. Currently, there's no legislative force to this ruling. What that means is that if the OSR simply does not like what you've done, they see that you've siphoned off some revenue streams to other entities to get this down under $5 million, it is completely within their right to say simply, no, we're not going to give you the exemption, and we're not going to give you the concession. In terms of anti-avoidance, I expect most of the accountants on the call will be very, very familiar with the current ATO's position, which is that if you're taking preemptive steps or you're using things like rollovers or concessions to be able to put yourself in a position to get a second concession, things like back-to-back rollovers and using small business concessions for transfers and restructures and things like that. From a federal income tax perspective, the Commissioner has said, yes, I'm going to seek to apply Part 4A in those circumstances in your anti-avoidance. From a state perspective, the state anti-avoidance rules are not as sophisticated as the federal ones. That being said, is it your client that wants to run the test case on this? If they've got that risk appetite, yeah, sure. But most of the clients I think we've ever acted for tend to turn their nose up when you say, well, you can do this, but you'll be in the high court trying to prove it. And that sort of squashes those kind of structuring options a bit on their head.
So I guess, Tom, just moving back, we're saying the turnover less than 5 million for the entity. And they're saying from our reading of it, it's the assets being transferred. The small business assets are less than $10 million. That's our reading of it, not the entity's overall assets. And certainly there's no test involved of trying to group in every related party's assets or the individual assets. It's not like that 6 million net asset test for CGT. It seems on this exemption ruling that it's just the assets being transferred are less than $10 million. So that, potentially gives a lot of scope where you've got, a business that has a lower turnover, but might be asset rich for a period of time.
I think on that, and we'll deal with this in some of the scenarios as well, there doesn't seem to be anything currently in this ruling against cherry picking which assets you want to go over. So for example, you might have a scenario where your turnover in any particular year is less than your 5 million. You could be a farming entity in a drought year sort of thing, but you could have, $5 or $8 million worth of cattle and property, plant, equipment, and all those sorts of things, for $20 million worth of land. In this ruling, there doesn't seem to be anything which is preventing you, say, transferring those trading assets, your property, plant, equipment, and your cattle out to a company but leaving the valuable land assets behind. Again, I would expect that to be tightened up once we actually get some legislation, but that's the current terms of the ruling as we read it. But I think
okay, Tom, talk us through the slide, hey?
A bit distracted. The idea is this, that so long as you get, though, you're under that 5 million turnover and you're under that $10 million dutiable value, you can go from an individual to a brand new company. Brand new company needs to have been dormant ever since its creation. So kind of had any assets, liabilities or anything like that. I assume they'd be happy with some paid up capital of $2 for the shares. But basically what needs to happen is if you're going from an individual to a company as part of this restructure, it's the individual who needs to take the shares in the company. Obviously, you would expect nothing less. In terms of a partnership, same sort of deal. The partners need to take in the new company needs to be dormant, and the partners need to take in proportion to their partnership shares prior to the restructure. So if, Steve and Kieran there sort of thing have 50% each, they need to take 50-50 in that new company. And if one of them takes a higher percentage, they're going to pay duty on their increased percentage as applied to the underlying value of the assets that are going over.
Then the interesting one, Tom, I guess, is trusts. So how does it work where you've got a trust that's got those business assets presently?
So
a discretionary trust, sorry, not your unit trust, a discretionary trust?
How it works is that you need to have the taker in default of the trust hop in as the shareholder of the new company, which I think it's a state taxes thing, and it harks back to the definition of a trust interest under the Queensland Duties Act more generally. So that's where it's come from. The weird thing here is that it is a complete mismatch with federal income tax for the rollover, usually a 122A rollover from a trust to a company, which says that the trustee or the entity is entitled to take shares in the new company. So it's a bit weird, and I'm not sure particularly why people would be restructuring out of a trust into a company in this circumstance where the taker in default needs to take the shares in the new company.
So just to summarise there is where it's a trust, is these rules say where you've got a business assets owned via a trust structure, is the ultimate company's still got to be an individual shareholder. So you're looking at who the taker of default of this trust is. And that just means, under the trust deed, who's entitled to capital on the vesting of the trust.
Or alternatively, when you've got those old provisions which say if the trustee hasn't made his determination or her determination by 30 June, it goes to, usually the principal beneficiary.
And the beauty is, I guess, is we can change these where it's between where the taker in default is changed, between a wide variety of family members or you nominate a taker in default. We can do that without incurring stamp duty. There's an exemption under 118 of the Duties Act for that. However, in this exemption ruling, they've said, well, you can't tailor it to, Tom being 12%, his wife being 30%, and his kids being 5% each. They've all got to be equal, all those takers in default. So that's a bit of a peculiarity.
I think I see Jake Allen just jumped in with a quick question, which I think is very much worthwhile bringing out. In terms of real property, this ruling has an expanded definition of what constitutes a business. So a business extends to leasing and licensing land in Queensland. So if you're in a residential type setting, I get the feeling the the Office of State Revenue would say, no, you're not in business. But if you've got, say, an entity that's leasing to the trading entity, an asset holding entity leasing to the trading entity, under this ruling, that asset owning entity will be considered to be carrying on a small business if you've got proper rent being paid over and all those sorts of things.
Now, Tom, I guess, when we think about that, where you've got a trust and we're getting it over to a company and it's an individual as a shareholder, it doesn't seem that great, as in, yes, we get to park that company tax rate at, that low amount of, what is it, 27 cents at the moment. But then we're still stuck with a bad tax problem when we ultimately distribute those dividends down to that one individual or two individuals. And so, it doesn't seem ideal, but perhaps that can be solved, because once we're in a company structure, if that's not land rich, well, then we can transfer shares pretty easily to more favorable entities like that discretionary trust we want without incurring transfer duty.
Yep, that's bang on. So,
and if we're eligible for those small business concessions or some CGT rollover relief, well, perhaps then that's not costing us anything, or, maybe we're kicking a little bit of money into super with respect to that transfer of shares too. So even though at first glance at this exemption, it looks like, oh, well, that doesn't solve anything because we've got individual owners, perhaps when we think about it a bit more and think a bit more into the future, perhaps there's some more effective planning that can be done to get us into that ultimate structure we want to.
Definitely. And I think on that, that's probably a nice segue into some crystal ball gazing when we get some actual legislation. Under the general corporate reconstruction exemptions for duty, there's a 3-year post-association period still in Queensland. So that is, if you do your reconstruction, you've got to keep going for 3 years, and you're not allowed to sell effectively for 3 years after you've done it. I'll be interested to see if that actually gets pulled into this legislation going forward. But we'll have to wait and see. It seems like an interesting one to bring up.
Martin Leonard here said, is there any indication that the asset transferred in tranches, i.e. 10 million in year 1 and 10 million in year 2? That's a good business, that one. That transferring a few other will not be covered by this exemption. The answer there is, well, you might be pushing the friendship a bit far, and we don't have it in legislation at the moment. So, we can't guarantee you what the Office of State Revenue does. If you try to, I guess, be a bit too greedy and take a bit too much, there might be more chance they go, no, you're pushing the envelope too far.
And I expect that probably, they haven't said this explicitly under this particular ruling, but there is a general aggregation provision within the Duties Act, which says if you've got, it was effectively to counter what's called contract splitting, which is what you're just describing, that you can't sell a $10 million asset with 10 separate contracts and get the lower duty amount on $1 million each. I expect if you try to do that, they'd probably say, well, for dutiable value purposes, we're entitled to aggregate, and all of that's $30 million, and therefore you don't get, you're no longer entitled to this concession. But we'll have to wait and see on that one. I would have thought they'll have to tighten up on that in the legislation.
Okay, I'll just quickly deal with a couple of questions while we're here, Tom. Jim, can a new trust with a taker in default, same as original, own the shares in Newco? Generally, no, a trust can't, under this exemption, straight away own those shares. Tom will be talking about an example where there's a partnership of trust where there might be some potential arbitrage where we might be able to get around that. But generally, no, your trust can't be a shareholder, straight away from this exemption. If we distribute to a trustee company, is a trustee company considered to have been dormant if all it did is act as trustee? Specifically, it says that it can't be a trustee and it can't be a beneficiary under the trust. So we've got to be really careful about setting up this entity, and typically we want a clean skin. And we don't want it to be, at least definitely don't want it to be a default beneficiary of any trust. Where there is no default beneficiary, who can be the taker of default then?
Usually you're able to find a default beneficiary in terms of capital, particularly if you don't have one in terms of income.
Look, there are a lot of trustees that don't have that. We'd have to have a look. Sometimes I know for land tax, they go through and have a look at who the principal is and that type of thing. But that's a question, I guess, Renee, we don't know a final answer yet. Oh, sorry, Bjorn, hiding as Renee. Thank you. Yes, it must be that individuals in the new company. Tom will give an example of where a discretionary trust might be able to be a shareholder. Yes, Mal, we're going to talk about partnerships of discretionary trusts soon. And so we'll deal with that issue then. So everybody, I think we'll move on. And I think we're into the stage where we can start talking about some examples now, unless you've got anything else to add for that point, Tom?
No, I think we're up to go to some scenarios. Be good.
All right, scenarios. This looks good. My name's on it. What's happening here, Tom?
So this is sort of where we think there's going to be some real potential with professional partnerships. And the reason why there's some good potential here is we've got Steve and Kieran, who are currently conducting the Merthyr Law partnership. And effectively what it means is we can get all of those business assets from Steve and Kieran, assuming they're under the 5 and 10, over to Merthyr Law Proprietary Limited. And also as part of the arrangement, at least for partnerships, we're pretty close to the federal rollover for under 122B. So in this circumstance, it looks like we're able to get the assets over to the new entity, CGT free and duty free, which is good, and without having to fall back on those small business concessions to try to otherwise mop up any gains that might apply. So this is quite a good one, but as you can see, Steve and Kieran are taking in their individual names in Merthyr Law there.
And then perhaps, Tom, we could look at perhaps transferring our shares to, our respective discretionary trusts if we were structured as individuals, and, perhaps looking at if we're entitled to small business capital gains tax relief for that.
Yeah, definitely. And then you're just going to have to hope that your small business concessions are going to work well enough to mop up any gain on those shares.
And so the advantage there is that obviously the company tax rate is lower than what Stephen Mine's, if we're Stephen Mine's marginal tax rate would be. And so, we can reinvest in the business rather than having to pay everything and pay tax at the top marginal tax rate to ourselves and then reinvest it in the business. We can keep a bit more working capital in the business. From, other entities too, it's still possible even, Tom, to, I guess, have some asset protection in this structure by, interposing holding companies and doing those kinds of things. So, you're taking some risk out of that operating entity, but you're still keeping it in that corporate group. So you could do those kind of mechanisms after you've done that initial transfer of those assets.
Definitely. And then, it's also great because it's getting the business with the higher risk business away from the partners who are individually, jointly and severally liable for any claims made through that business into a corporate entity where you can sort of at least put up that initial barrier to saying, well, no, you don't get to sue us as partners personally, you have to sue the business. And,
it's possible there's existing proper legislated exemptions for corporate reconstruction. So, you could put up subsidiaries, put up, if there was land, put the land in one subsidiary and, your valuable IP and et cetera in another subsidiary. And that could all happen if structured correctly, and you could transfer those assets around the group without stamp duty and without capital gains tax if, you've got a proper consolidated group there. So it works well getting it into consolidated groups. But, if you're already in a consolidated group, you're already in that company environment, so you can't do anything there, right? Was one of the questions we had.
If we move on to the next one. This is, I think we described this a bit earlier in the session. We've got here Abe and Mona, who are a farming partnership, husband and wife. The farm, after many years of inheritance, is worth 20 million, and the cattle and PPE is worth 7 million. So this is our reading of the current ruling, which is we can cherry pick which assets are going to go over to the new entity. So in this case, we're leaving the farm behind in the partnership. So that would just be Abe and Mona going forward. But they've been able to get the cattle and property, plant and equipment over to this new company, duty free. So they've been able to get at least some of the risky aspects of their business out from them personally, and that joint and several liability to which the farm is also potentially at risk, through to a separate entity, and you've got a bit more asset protection there. And on top of that, you've got the ability to stash cash in Rural Route 9 Proprietary Limited, rather than have to take those distributions at the highest income rate. Depending on the distribution from the partnership at potentially the highest marginal tax rates. So that's very good for Abe and Mona going forward.
All right, moving on. So here we have got a pretty common scenario where the Fry Trust operates a business, and it's been earning some money and doesn't have enough individuals to distribute that to tax effectively. So it's been making distributions to a company. And that's created, you know, a large UPE, unpaid present entitlement account, and Division 7A loan owing by the trust to the company. Tom, what are you suggesting here?
So this would be about the most common scenario you will see with every single trading trust in Australia. In this one, what we're trying to get at here is we can use this concession to get all of those assets out of the Fry Trust and into Fry Proprietary Limited. And we can also structure it properly, end up with a loan between two companies, and which is, for Div 7A purposes, disregarded under 109G. So it means we can deal with a lot of those old problems of Division 7A and UPE loans and things like that. And again, structured correctly, you know, if we pay full value for the assets, and most of the time, the assets going over will be in and around the Div 7A amount. You can do a bit of a round robin of cash, or you can borrow some cash and round robin it. And you can legitimately get all of the Div 7A loans out of your trust and over into a company, which is then just disregarded. And you can sort of breathe a bit easier going forward, which would be nice. The magic here is fitting it into the requisite federal income tax rules or small business concessions to otherwise try and minimise the capital gains tax on it all going over, or otherwise try to minimise the income tax, particularly if you're dealing with things like stock going over or depreciated assets.
And one thing I guess we didn't cover so far, Tom, but we quite commonly see when we're looking at restructures is vehicle registration duty. So sometimes you've got businesses with lots of trucks or hire equipment that are registered, and you know that's a separate head of duty, and then we do the sums, and it's a huge amount of duty that's got to be paid to transfer vehicles over. So the good news is this exemption applies to those vehicles.
It's one of those joys that I don't think things like the primary production exemption for family transfers of farms, or some of your other, even things like trustee exemptions, actually extend to vehicle registration duty. So even if you do get other concessions, you may well be stuck with vehicle registration duty on all of it all. And I think. All
right. So this is the peculiar situation, I guess, is when you might recall when we're looking at eligibility, our partners are eligible, but of course we can have partnerships of trusts. So Tom, what's the story here?
So the main reason we wanted to bring this out, and I'll preface it by saying this is one of those back-to-back exemptions or back-to-back concessions, which need to be understood and taken with a grain of salt. But this is particularly to illustrate 2 points. And one, this has been a bit hastily drafted, and number two, under the partnership parts of this ruling, or the partnership concession in this ruling, it's the partners that need to take the shares in the new company. And the common scenario then came up is, well, what happens if I have a partnership of trusts? We put this to the OSR just in a completely non-binding sort of, hey, we've got this query. What do you reckon? And the response we got back was, if you've got a partnership of trusts who are seeking to use this concession, they need to take in their trustee capacity, which is good. If you've got, say, Sherry Trust there, who Sherry is the taker in default and should otherwise be stuck with it all, if she were to either clone duty-free 1% of the trust's assets out to a separate Terry Trust, or alternatively just sell 1% to the Terry Trust and create a partnership of these Sherry and Terry Trusts over those assets, she could then use this ruling to transfer from that partnership of trusts out to the new company, with 99% owned by her original trust, 1% owned by the new trust, and her having successfully avoided having to take those shares in her name personally. So you get to that sort of gold standard of current structuring, which is trading company that is owned by discretionary trust or a set of discretionary trusts in these circumstances. So that's to illustrate, those 2 points that, hey, partnership of trust needs to take in their trustee capacity, and there doesn't seem to be any commentary yet about back-to-back concessions and claiming back-to-back concessions. Again, I expect that to be tied up once we get some legislation. I would expect that you'll have probably some sort of timing type rulings or timing type views, or that broader duty substantially one arrangement kind of thing, to say that you can't do a lot of these, but as the ruling currently goes, that's where we stand.
Sounds interesting.
And I think this is the last one.
Okay, so property, this is particularly about property developers. We've got a farm here. What's the story here, Tom?
So here we've got William and Doris owning a farm, and we're going over to Tractor and Co. owning the farm. The reason why we brought this up was for property development. And it's not uncommon, or maybe we just see it, is it not uncommon, that when people acquire a block of land and they're going to start holding it on revenue account as trading stock, or they're going to start seeking to develop it. Currently, if they're partners, they're going to need to get whacked with all of that income in their own personal names as soon as it comes in. And the question is, well, if they're at the start of the process, or at the start of the development process, and we've got it in the Warring entity, or we've got it in William and Doris, can we transfer it over to, say, a company and allow us to sort of manage those income tax consequences a bit better, because we can just continue to do the development within Tractor Co. and sell it off more generally? And the answer is yes. We can do that in these circumstances, subject to being able to manage the income tax consequences. But yeah, under the duty rules, whereas you might otherwise have originally got stuck with a very heavy, lumpy asset in the wrong partnership, you can now get it out over to Tractor Co, which would be very, very good.
Yeah, so Tom, I guess that's a perfect example is, someone who was a farmer on the outskirts of town and now became, more part of the town where, there's a potential to subdivide that into residential development. And, let's say their intention changes, they become a developer, they're running a business then. But they're busy trying to get development applications and sort out the whole project, and their revenue is going to be, reasonably low. So I guess there is that kind of sweet spot there where, they might be able to get that over to a company. Then when they're selling all of those lots, they're paying that company tax rate. Then they're going on their holiday around the world. And instead of copping that all in the 1 year, they're distributing that out, over a couple of years and saving a bit of tax there. I've got a client where, they'd done it the wrong way. They'd bought all of these farms in one person's name, with a joint venture funder. And they're like, Kieran, how do I fix this up? We'd much prefer to be in a company structure for the development moving forward. And, stamp duty, we're looking at, well, maybe we'll have to pay that. And so potentially now that we're running this farm and, it's that time to transfer it over and there's not significant capital gains with respect to that asset, it seems like, we might be able to structure it in a manner where, we can move that over to a company without attracting that duty.
Definitely. And I think the other point to bring out here is that it also, once you're in a company structure there, owning the nice lumpy farm soon to be housing asset, you can bring in third-party investors pretty well into there as well, up to 50% without having to pay any stamp duty. Because obviously once you've got more than a $2 million property in a company, it becomes land rich. After that point, as soon as you have more than a 50, or as soon as someone either by themselves or jointly with others acquires a 50% interest, you start having to pay stamp duty on that.
So in that example I was just talking about then, where we've got one person who, is the legal owner of the land, there's another person who's funded that, and there's been a deal that the funding would get repaid by a distribution of the receipts. Perhaps that means that that's a rollover where, there's that one shareholder to start off with. But then if that shareholder is divesting less than 50% of the shares in that company to the other investor, we've got in there without paying any stamp duty because we're less than that 50%. I think that's a great structure for, where you've got that situation.
Definitely.
Now you're in a company, you can also go and, you're not going to get those big stock land developer investors. They don't want to be looking over, your little joint venture agreement and your discretionary trust. Everyone understands a company structure. And so then it's a much better structure for getting new investors along and to move into that next space for that bigger enterprise.
Definitely. Lovely.
So I guess, Tom, before we get onto the questions, the crystal ball gazing, I guess, we're in a quandary at the moment, aren't we? We don't have, you want to know the certainty of the law so we can give an unequivocal advice saying this is what the law says, this is what you can do. Instead, what we've got is a ruling from the Office of State Revenue saying we're prepared to give ex gratia relief on the following basis, but there's still an element of we don't know exactly how the Office of State Revenue is going to apply this because, the ruling's a little bit light on. So who do you think are the people who are going to be adopting this before it gets legislated?
I think the people who need to really look at this, and if they want to get it done ASAP so that they're in the right structure for a post-COVID kind of recovery, those ones where it's a nice clear application of the ruling. If you're straight out partnership and you're under 5 million on any day of the week and you're under 10 million in total assets going over, that would be a good one, or individuals, or just those really basic cases where you just tick everything off. If you've got something a little bit more fancy, for lack of a better word, you'd be wanting to hold off, I think, until you got some legislation.
And for example, though, Tom, I guess we've already got a couple of clients in our book who said to us, just like Laura's example before, although they'd said to us, oh, geez, we're prepared to cop that duty.
Yeah, those are the other ones. I'm doing one of those at the moment where there was meant to be a straight out restructure and the client said, I'm not happy about this, but I'll pay the duty to get in the right structure. And we're now in a situation where we've got pretty good legs to get up on this ruling. So if the clients were already in a situation where they were going to be paying the duty, and you can now turn around and say, hey, there might be a shot at you not paying the duty, but if you do pay it, hey, you're no worse off. Well, you could well have just saved the client $200,000, $300,000, $400,000. So anyone who was already looking at doing the restructure and was happy to pay the duty, or anyone now where it's the more basic case, seem to be the really, really big winners out of this one.
And Tom, from a tax lawyer's perspective, when you do find clients in that boat where, you've managed to structure it in a way and, they've found an exemption where, they're now saving potentially hundreds of thousands of dollars, that's a pretty good feeling, isn't it? That's part of why you do tax law. That's what you're looking for.
What I live for. Yeah, no, it's great when you can do that, and it's great when you can pull off those sort of wins for clients. So, love it.
So, everyone has been very prolific in their questions, and I have been delaying a lot of them until the end now. So keep those questions coming. I understand, we're almost at 12 o'clock now. So if you need to leave, I understand. We'll try working through those questions now. And, just after 12, I'll award the wine for who's left. Let me see. Do you see that? It's a big stein that Tom drinks his water from. It's he doesn't like to be pulled away from his textbooks for too long. So he just has a big stein at the start of the day of water to get him through the day.
I just look at it and wish it was filled with beer, but
the textbooks behind Tom, they're just what do you call them? The decoration. Tom's actual room, we didn't let him film this from that because there are textbooks everywhere in every which order, and that's the way a lot of tax lawyers work. So if you're wondering if a tax lawyer's office is this neat, the answer is no.
Ooh, not in the slightest.
Okay, Mel Whitehouse. I have a retail property held by 4 entities in partnership, including 3 discretionary trusts and 1 individual, my wife. Can I transfer the interests of the 3 trusts to my SMSF? Yes, you can, but you don't need this exemption for it. So this exemption's not to apply. The SMSF is a trust, not a company. However, I'm glad you asked that question, Mel, because we have got another exemption where we're able to get commercial property from a trust to a self-managed super fund without stamp duty. And how do we do that? We align those default beneficiaries up of the family trust with the membership interest in the super fund. And then we do a declaration of trust, which is a different way of structuring it. We align the trustees, do a declaration of trust, and then there's a specific exemption under the Duties Act where we get that. So I have personally had clients, who were about to pay the $200,000 duty, and we've got that exemption for them. And it is a good feeling getting them that. I'm actually having lunch with one of the accountants that's here today, lunch with a client that we got that for. So they like us so much. I think the client's even paying for lunch. Bjorn, acting as Renee, is it possible for different enterprises within the same trust to be rolled over into different companies? Great question, Bjorn.
So on the current terms of the ruling, yes. It appears in the same way that you can cherry pick and leave assets behind. You can say, well, this particular, effectively a demerger sort of thing, this particular aspect of the business is going to entity A with the correct shareholders. Same deal for this particular, part B is going to entity B, part C is going to entity C. So yes.
Okay. Laura, any mention of where the revenue was derived, i.e. if it's not in Queensland? So no, I don't think the ruling covers off on that. It's just a straight revenue. It's not like when, we've got a multi-jurisdictional business and we apportion the duty between states. That's not the case here. I think via the ruling we're looking at, it's just on a straight revenue basis. Doesn't matter where that revenue was derived.
Just so long as the business is at least in part conducted on or from a place in Queensland.
Jim, can Abe and Mona transfer their 50% out to a company of their own? Let me remember what Abe and Mona were.
Partnership. So are we saying, can we get 50% from Abe to Abe Co and 50% of the partnership interest to Monaco? On my reading, no. On my reading, they have to take it's effectively, you need to go from partnership to company owned by the partners, 50-50. You can't sort of go company A. On my reading, you would have to go to company A, Abe and Mona, company B, Abe and Mona, and then they have to transfer their separate interests in the company to get to that.
Yeah, and they're quite clear about that if it does go different than the partnership interest, you've got to pay duty on that percentage difference. But there's always other ways to skin a cat. So, get in touch with your local tax lawyer and see if he's got another way of structuring it to achieve that end purpose. I am a sole trader. I have a commercial building in my name. Please explain what is involved in risking the anti-avoidance ruling if I wanted to transfer this property to a company.
So there shouldn't be any issues with anti-avoidance rules so long as you're under the $5 million turnover and the value is less than 10.
But Tom, this commercial building, let me be clear, does that have to be part of the business? So it needs to be a business asset? So if you're just tenanting out a commercial building to third parties,
the way that this is currently drafted is that small business entity is extended to include supplying rights to use property in Queensland. I think I'll get the exact wording. Is a business which conducts wholly or partly of supplying land or interests in land to Queensland customers. So my reading of this current ruling is that if you own a commercial building and you've got commercial tenants, you're a small business for the purposes of this ruling, and you could get it over to a company. The thing to be aware of there is you're going to lose out on your general discount by doing that. And it's also whether or not you want, CGT general discount, and that's also whether or not you want your property in a company structure. Various reasons for that. If it's asset protection, yeah, go for it. With the coming down of the corporate tax rates, the loss of the CGT general discount isn't that much of an issue. And particularly if you're in a sole entity or sole individual owning that asset, it might be better to get it out to a company, but it depends on the circumstances.
Now, Mel Whitehouse has said to us panelists, I'm having a beer now for you. So he's having a beer to celebrate for us. So I like to hear that, Mel. Tom brews home brews in his time off. So he always likes a bit of beer chat. But back to the legal questions. Jim's asked, what value would Tractor Co have as a cost base? So the cost base would just be rolled over generally, wouldn't it? It'd be if it purchases price.
We'll just separate it out that there's a separation between duty in this concession and income tax under the federal rules. For income tax, Tractor Co would, depending on how you did it, if it was under a rollover, generally Tractor Co will take it at the cost base of we had, I think it was Willie and Doris. They'd take it at Willie and Doris's cost base. If you did something like use a small business concessions, you'd refresh the cost base, and the cost base in Tractor Co would be the market value of that land as at the time of the transaction.
Okay, next question. Paul Ryan, any clarification on our partnership of family trust with a turnover of 5 million, being able to divide it by the 3 partnerships of turnover over 5 million, being able to divide it by the 3 partnerships to be under the 5 million?
It's the partnership that needs to be under 5 million. So you've got, you can't have sort of 3 trusts with a turnover of 15 or 14,999 and say, well, you take 5, you take 5, you take 5. Hey, we're under 5 altogether. It's the partnership entity which gets the concession under this ruling.
So, Paul, we'll still be thinking about your situation, but we haven't found an answer for it yet. But it's not to say that we're not thinking about it. Any other questions? Look, I don't think so. There will be a bonus point for anyone who can pick what, if Tom is also a animated cartoons nerd, and what cartoons that might have been referenced by some of the characters today. But in the meantime, it is time for the prize, Tom. I know I do have 2 bottles of wine here, and the questions have been great. So instead of just 1 bottle, I might award 2 bottles. Look, I've got to be pretty impressed with Laura's one, with that client since the 1990s with the Div 7A issues, on the classic one with going to pay that extra stamp duty, but with the turnover slightly over. I think that was a pretty good one. So Laura, if you let us know if you want the Chardonnay or the Cab Sav, and they're both fantastic bottles. When I picked them up to do this, I thought I'd siphon one off to myself and have a glass before the conference, but I didn't get a chance to. So you've still got 2 bottles at the end of today, and I'm giving them both away. Now, who would be the next one who has contributed a lot? Oh, Laura's gone for the red. The cabbie didn't take her long. Nice to know she's still listening. All the ones who've asked those good questions are still hanging around to see. Who else do you reckon, Tom, out of all of those questions?
Having a quick spin through.
Norbury was pretty good. Bjorn was pretty good. There was lots of good questions.
I'll leave it to the expert to decide.
Oh, Jim, you participated pretty well. So I think a bottle of Chardonnay coming your way, yeah, providing you drink white. Otherwise, we might be able to be in touch with another alternative if you don't like that. And has anyone figured out all of Tom's cartoons for the bonus prize? And Laura has asked me if I could please keep this private from her husband, Dan, because she might be able to drink more than 1 glass of the bottle if she manages to have it separately from her husband. So I don't think he's on this conference today. So, yeah, we can keep it quiet. Laura? And Jim prefers red too if we have extra. So we'll be in touch. Maybe I still do get to, maybe you and me get to drink this this bottle of Eileen Hardy. And I guess that kind of wraps it up for today. Now, what to from here? Like, you know, I know there's a lot of if buts and a lot of grey area with respect to this exemption, but I guess the takeaway for this is if for you or for any of your clients, if you sat down and thought, what would my ultimate structure be if capital gains tax and stamp duty wasn't a problem? What would I be running my business for? And I think that's the reason why these exemptions are there, because the government wants businesses Queensland businesses to do as well as possible and want them to be in the best structure to attract new investors, to do well, employ people, grow. So have a think about that. And if it is different than the current structure and you want to get into that company environment, perhaps it's worthwhile getting in touch with us and, you know, giving us a look at what the situation is and figure out, you know, if there's any opportunity there. And, you know, we always work on that basis. You know, for those initial look at, sometimes it might take us a couple of hours to look at it. We give a fixed quote for that. And, you know, we always give a pretty kind of low quote just for having a look at those documents. So, you know, there's no surprises. You're not going to get $100,000 bill just from us having a look at something. You know, we're very transparent about, you know, if it would cost anything, just a general chit chat often doesn't. And two, you know, if it is something we have to have a decent look at and have a bit of a conference with the advisors or the clients, you know, we'll give a fixed price for having that look at all of that. So, you know, that's kind of that way forward. And look, we're excited. I personally think, you know, be brave. Don't wait for the legislation to ruin all of this opportunity at the moment. But you've got to be, you know, a certain level of confidence to do that when it is just a 3-page ruling rather than 20 pages of legislation. So, Tom, thank you so much for taking your time. I know how busy you are at the moment to put this together and explain this new exemption to all of our Merthyr Law crew. And everybody, yeah, we'll be in touch, and we'll be in touch with respect to that wine.
Thank you very much, everyone, for attending. Appreciate it.
Thanks, everybody. Dick Gavin's not impressed. We missed him out. Sorry, Dick. There was a lot of questions. I'm sorry I missed you. All right, Tom, we'll call it there. I think that's pretty good. 10 minutes over. That's about perfect.